Since 1932, Kincaid Mendes Vianna Advogados has been recognized for its performance in Brazil and abroad, in the air, on land, and at sea. With headquarters in Rio de Janeiro and offices in São Paulo, Brasília, and Vitória, we operate with a network of associated firms in various regions of the country. Our team supports diversity and inclusion, consisting of lawyers from different areas of law to advise our clients in the most complete and effective way. In-depth knowledge in the sectors in which we operate. We have the experience required to innovate, seeking creative solutions for today's and tomorrow's challenges. We want to contribute to your story. Kincaid Mendes Vianna Advogados. Deep understanding for unique solutions.
Good morning. Good morning and welcome on board. I would like to thank everybody here for participating in this webinar. It's a pleasure to have you all with us today. My name is Roberto Kurtz. I am the labor partner at Kincaid. Here with us today is Juliana Carneiro, who is an associate in our team. She will moderate the Q&A section that will happen at the end of these positions. So if you want to add comments or ask any questions to the speakers, feel free to use the chat tool. This is our 5th event in the Shipping and P&I series. Until now, the topics covered were green shipping and pollution prevention, cyber risks in shipping, ship registries and port state inspections, and EBL, paperless trading, remembering that all the recordings are available at Kincaid's channel on YouTube. Today, we are going to discuss the Maritime Labor Convention with a high qualified group of speakers composed by Augusto, Grieco, Sant'Anna, Meirinho from Brazil, Richard van Zelfde from the Netherlands, Cecilia, Cavana from Italy, and Robert Robinson from England. They will share their experiences about the Maritime Labor Convention in their countries, especially related to its implementation. The MLC, as you know, is an international convention designed by the International Labour Organization, and it's considered the 4th pillar within the most important maritime convention with SOLAS, MARPOL, and STCW. It has a massive relevance in the maritime work as it integrated multiple conventions regarding the theme into one broad convention. The MLC has already been applied in other countries since 2013. But it became effective in Brazil only in May of 2021. And because of that, we are still dealing here in Brazil with a lot of discussions, including the adaptation of MLC into domestic legislation. So I do believe that understanding what were the main issues that occurred in different countries make it easier to predict what are the main challenges we could face from now on in Brazil. Without further ado, let me introduce our first speaker of the day. He is Augusto Grieco Sant'Anna Meirinho, a Brazilian labor prosecutor that will present us his opinions about the MLC as well its compliance and inspections. Augusto has a doctorate degree in social relations rights and master's in social security rights. He's a specialist in labor law, a specialist in international relations, and is a Bachelor of Nautical Science. Augusto, thank you again, and the floor is yours.
Thank you, Roberto, for the presentation. Thank you for introducing me. It's very kind. Good morning and good afternoon, everyone. I would like to thank Kincaid, Mendes, Vianna lawyers for the kind invitation to talk about the Maritime Labor Convention and its implementation in Brazil. I take the opportunity to congratulate also all the speakers present here, Dr. Cecilia, Dr. Richards, and Dr. Robert, who will brighten the event with their experience and their knowledge. It's an honor to be here with you. Thank you very much. I also to greet our moderators, Dr. Juliana, Carneiro, and Dr. Roberto, Kurtz, my friend. Thank you very much for your the invitation. I'm very proud to be here. Mainly, I would like to salute all the people who are watching us, sharing their time with us to address this important issue that is Maritime Labor Convention, important to Brazil and to all seafarers working in the shipping industry here in our territorial waters and everywhere in the world. I will try to share a small presentation that to hope to turn more easy to follow my talk here. Let's try. It's okay.
It was okay, Augusto.
It was okay.
Yeah,
let me see.
Now, try it again, please.
Let me see. 1 minute. I think I pushed the wrong button. Let me see. It's okay now? It's okay? Okay. Okay. Sorry, it's the problem in the operator here in the front of the keyboard. Well, let's start here. First of all, I would like to highlight the Maritime Labor Convention adopted by the International Labour Organization, the ILO, is an important legal instrument for the decent work agenda on board ships. It's very important to understand that we are talking about decent work agenda in a special industry with the vulnerability of the seafarers. It consolidates in a single normative document several conventions adopted by the organization since this creation in 1919 related to the maritime industry. In Brazil ratified the MLC on May 7th, 2020. That entered in force on May 7, 2021. As a result of the process of internalization of international treaties in Brazil. The Presidency of the Republic published in April 12, 2021, a decree, it's number 10671, which promulgates the Maritime Labor Organization. Decree in Brazil, it's a kind of normative below the ordinary legislation. It has the proposal to tell the Brazilian society, the nation, that the convention, in the case the MLC, has been ratified and has become law in Brazil. Therefore, the MLC is law enforced in Brazil, in my opinion, since May 7, 2021. To answer the question about the implementation of the MLC in Brazil, I would like to make some observations. Due to the nature of the MLC, it's an important observation, that's an international human rights treaty. It's possible to recognize a special normative status in Brazil. Here in Brazil, we talk about a supralegality, which places the MLC between the Constitution and legislation. The MLC could not be modified for that reason by the National Congress, because its special status of supralegality above the legislation, below the Constitution, above entire legislation, because it's a treaty regarding human rights. This is important because it brings more legal stability to convention, especially in the judiciary branch, especially in the labor courts in Brazil. The MLC itself contemplates the principle of the most favorable standard, in addition of the recognition of collective labor agreements and conventions. So after this brief explanation of MLC position in the Brazilian legal system, I think we could move on the discussion about which government agency will be responsible for implementation of the convention in Brazil. That is already a law in force. In Brazil, both port state control and flag state control are run by Brazilian Navy. So the Maritime Authority, which is the Navy commander, is traditionally responsible for implementation the conventions, the principal convention that Roberto has talked about, the International Maritime Organization conventions, the principles, the three principles, the SOLAS, MARPOL, and STCW. Traditionally, inspections by or of ILO conventions were under the responsibility of the Ministry of Labor, which created a special group of labor inspectors to work in the sector. Important to tell that the Federal Labor Inspection System, under the responsibility of the Ministry of Labor, has the mission to ensure throughout the national territory, the Brazilian territory, the application of legal provisions, including ratified international conventions and the collective labor contracts with regard to the protection of workers in exercise of labor activity, including aboard ships. About the MLC, the federal government created a working group with the objective of harmonizing the role of each federal agency in the implementation of the Maritime Labor Convention. I have the opinion, it's my opinion, from positive experience in interagency working in the past, that the Brazilian Navy should coordinate the port state control and the flag state control, leaving the specific labor aspects of the Maritime Labor Convention to the Ministry of Labor, such as working hours, wages, payments, minimum wage, habitability, and comfort aboard ships, etc. This system would be essential for the maximum efficiency of the state's performance, especially because the Brazilian Navy already has the expertise in enforcing compliance with the main International Maritime Organization conventions, SOLAS, STCW, MARPOL, this one, which have aspects related to sea affairs. So the Navy has already the expertise to enforce these conventions. In my opinion, the Navy should remain with these obligations. It's also important to highlight the existence of the labor prosecution officer, which I belongs, the MPT in Portuguese, which is an institution dedicated to defense of the legal order, the democratic regime in Brazil, and fundamental rights. With the scope of the MPT, a national coordination was created to act strategically in the port and maritime sectors. We call it CONATPA. And one of the coordination's main attentions in maritime work, given the vulnerability of sea affairs. The vulnerability of these workers is accentuated as a result of carrying out their professional duties, activities in an environment of isolation from the rest of society, which gives them a certain invisibility. This reality was clearly demonstrated by the COVID-19 pandemic, especially the difficulty of disembarking and change crews. In Brazil, in general, working conditions on board the merchant ships flying the Brazilian flag are usually adequate, especially due to the performance of inspection by government agencies, such as the Brazilian Navy and the labor inspector. However, I think it's important to tell to you, there is a real risk that the scenario will change in navigation along the Brazilian coast. Depreciation of the maritime work environment may occur as a result of a process of flexibilization of the flag rule in navigation along the coast. We call that cabotage. In Brazil, the promulgation of the Maritime Labor Convention comes to at a strategic moment in which a future bill number, I think is 4199, known as BR do Mar, BR of the Sea, is being discussed in the Federal Senate. This is because the reference bill provides in its Article 12 that international rules established by international organizations will apply the employment contracts of crew members operating in a foreign vessel chartered in the form of BR of the Sea. I think you can go on with the slides, please. Another one is I have already told, okay, you can. Yes, I think it is this flexibility would lead to a proliferation of ships with flags of open register, flags of convenience, since the predomination factor for the proposed changes in the law is the economic one. Principally, the operational cost of the ships, including the cost of the crew. You can to pass from, yeah, thank you. Yes, perfect. So in this scenario, it is reasonable to assume that ships that may come to operate in Brazil under this circumstance, if there is no effective control by the Brazilian authorities, would be substandard. The great concern to the Labor Prosecutor Office, the MPT, is that the number of occurrence of ship abandonments increase as a result of the greater number of foreign flag ships operating in Brazilian jurisdictional waters in the future. Although the prospects for improving the social conditions of workers at the sea have been raised to a formal level converging with the decent work agenda with the ILO's MLC, it's essential, in my opinion, that its implementation be imposed by the states. So, concluding, it's up to the Brazilian state to carry out an effective control through its specialized agency of the compliance with the MLC by the companies that operate the ships in Brazilian jurisdictional waters. In my opinion, I think it is the Brazilian Navy that has the expertise in improve these instruments. Now, this fourth pillar in the safety of navigation and the increase the conditions of living aboard the ships. Well, I hope I haven't exceeded myself in the time available to me. Sorry about the problem with the presentation. You could put pass the slides, please. Okay, I have already talked about that. So I thank you very much. I appreciate again the opportunity to be here with you. My contacts are in the slide. Thank you very much. Thank you for the invitation. I return the floor to the Roberto. Thank you very much.
Thank you, Augusto, for the excellent exposition. In the last 30th of September, we celebrate the World Maritime Day, which theme of 2021 was seafarers at the core of shipping's future. So I feel that your presentation is very relevant because emphasize that the workers' safety is the main concern. Thank you again, Augusto. Now I invite our second speaker to give his standpoints about MLC in the Netherlands, including some practical cases. Richard van den Zelfde is a lawyer at Caland Advocaten. He has a specialization course in transport law and is a member of Dutch Association of Transport Law, Dutch Association of Transport Lawyers, and overseas representative for the Edinburgh Academy. He publishes articles in specialist literature, and he also is a co-author of capta zirit in aspects of maritime law. Please, Richard, feel free to start when you are ready.
Thank you, Roberto, for the introduction. And thank you, Kincaid, for organizing this event and for the invitation to speak. I will talk today a little bit about the implementation of the MLC in the Netherlands. I have, sorry about that. Yes, the implementation of the Maritime Labour Convention in the Netherlands. On the 23rd of February, the International Labour Organization adopted the MLC 2006. And it did so in a desire to create a single, coherent and up-to-date instrument that would embody the fundamental principles that was found in other international labor conventions. Now, among these other international labor conventions, there were 37 prior ILO conventions. And of those 37, the Netherlands had already ratified 17 conventions and implemented some of those into the Dutch domestic law. As Augusto has also already said, it is often referred to the MLC 2006 as the fourth pillar of international maritime law, with, of course, the first three being the SOLAS, MARPOL, and STCW. As per Article 8 of the MLC, it would enter into force at a certain date, namely 12 months after ratification by at least 30 members of the ILO that had a total share in the world gross tonnage of ships of 33%. And that number of ratifications was reached on 20 August 2012, so that the MLC 2006 entered into force on 20 August 2013. The Netherlands had already ratified it on 13 December 2011. Now, prior to this ratification, already on 23 December 2006, so about 5 years prior to ratification by the Netherlands, the Dutch government had contacted a specialized labor law professor, namely Mr. Heerma van Vos of the Leiden University. And he was asked to advise the Dutch state on the implications of future ratification of the MLC 2006 and subsequent implementation into Dutch law. And the labor law professor studied the MLC 2006 with a specialized group, all consisting of labor law specialists. And on 16 March 2007, they issued their report. And in that report, they have identified in how far Dutch law was already in line with certain requirements by the MLC 2006. And it turned out that that was already the case for quite a number of provisions. We were already in line with that convention. The professor also came with a number of advices, and his preferred advice to the Dutch government was to draft a new Dutch law that would fully incorporate the whole MLC 2006. And of course, the reasoning was that it would be clear we would have the whole convention in one convention text incorporated into Dutch law. Now, unfortunately, that advice was not followed by the Dutch state. The Dutch state considered that Dutch law already met quite a number of MLC 2006 requirements in existing Dutch law. And it stated that therefore there should be no preference for a new law fully incorporating the convention. Instead, the MLC 2006 obligations would be incorporated into already existing Dutch legislation, of course with some amendments here and there. That implementation subsequently took place into a great number of already existing Dutch laws. We have the Dutch Civil Code. It consists of a number of books. And in Book 7, we have the provisions on Dutch labor law. It was implemented into Book 7, into the Dutch Code of Civil Procedure, into the Port State Control Act, the Working Conditions Act, Placement of Personnel by Intermediaries Act. Of course, we are thinking about the manning agents there, the Economic Offences Act, and the Dutch Criminal Code. And only for a slight number of the MLC obligations, a new law was drafted, the Seafarers Act. But that is only for a limited amount of provisions. Now, the consequence has been, unfortunately, that the MLC 2006 obligations and provisions are now dispersed over several Dutch laws. So you need to know your way around Dutch law to find those provisions. To give an example, in Book 7, we have a new article 738A, which contains the obligations contained in standard A2.5.2, paragraph 9. So that is the obligation to have in place financial security, to provide abandoned crew with wages up to 4 months, and also the repatriation. In the Wet Zeevarenden, we have obligations of regulations 5.13. So the obligation to have a maritime labor certificate and the declaration of maritime labor compliance. So in practice, it's a patchwork. And we also see that in the number of publications that have appeared since then. There are only a very limited amount of relevant publications in Dutch literature on the MLC 2006. And where normally those publications would be written by, let's say, maritime lawyers or maritime professionals, this is not the case. They are written mainly by specialized Dutch labor law specialists. Now, at the same time of the implementation of the MLC 2006 in the Netherlands in Dutch law, we have used that moment to modernize already existing Dutch maritime labor law. Some provisions existed already since 1838. And it was the second time in about 200 years that such modernization took place. The previous time was in 1930. So on the one hand, we see the implementation of the MLC. On the other hand, we see a modernization of the Dutch maritime labor law anyhow. The inspections in the Netherlands on board seagoing vessels are performed by the Inspectorate of the Human Environment and Transport. We refer to them as ILT. The ILT inspectors in general are, let's say, ex-crew members, ex-seagoing personnel, so they normally know their way around ships. Both the flag state control for Dutch flagged vessels and the port state control for foreign flagged vessels is performed by ILT. We have, for foreign flagged vessels, we have provisions implemented into the Dutch Port State Control Act, Wet Havenstaatcontrollen. So under Article 3 of that act, an inspector of ILT can go on board and he can submit a vessel to an inspection or an elaborate inspection or a more detailed inspection. In case of a repeated or a severe trespass against MLC 2006 provisions, the ILT inspector will detain the vessel. That is an instrument of Dutch administrative law. Then you are dealing with Dutch administrative law. We have one lawyer in the firm that specializes only in administrative law, and he normally assists in those cases. Of course, the ILT inspector will then inform the flag state of the detention, and instructions can be given to the master of the ship, for instance, to moor or berth at a certain designated location. And the master will then be forbidden to sail away with the vessel, of course. Now, as to the types of cases that we deal with in our practice, I mentioned already the cases where we act for owners of a vessel that are detained by the Dutch authorities. We deal with cases for P&I clubs that have had a member that was either bankrupt or about to be declared bankrupt, but who had, in any case, let the crew unpaid already for several months. Of course, the bankrupt member received claims by ITF, and we dealt with those claims on behalf of the P&I club. Also, we took care of the repatriation of the crew, and we investigated the possibilities in the Netherlands for the club to obtain repayment from the ship owner. We have personal injury cases where we act on behalf of the ship owners and their P&I underwriters. We have a very recent, or the most recent example in the Netherlands is a case I dealt with on behalf of the ship owner. A crew member alleged that he slipped on the shower floor and that he suffered injuries, and he held the owners liable. And in the Netherlands, we have a direct a claim in personal injury cases also against the involved underwriter. Now, in the court proceedings, the claimant stated that the shower floor did not meet the standards that were set by the MLC 2006, and that therefore there was a trespass against Dutch law. Article 685, 58 of Book 7 of the Dutch Civil Code provides that an employer should provide a safe working place. And obviously that is not the case where the shower did not meet the standards set to it. But we were successful in proving that the floor did meet the standards set by the MLC, and subsequently the case was won. And of course, we deal with claims where the crew remain unpaid by their contractual employer, for instance, a crewing agent or another party, and then they seek recourse for payment, not against that contractual employer, but what we call in the Netherlands the factual employer, namely the owner of the vessel. And they will try to enforce it also by court auction. So those are mainly the types of cases that we that we see related to MLC 2006. And well, I thank you for your time, and I welcome your questions later on.
Thank you, Richard, for an excellent presentation on the issues related to MLC in the Netherlands. You made some very interesting observations about the MLC provisions and obligations are spread over several Dutch laws. Sounds like patchwork indeed.
It is, yes.
Our next speaker is Cecilia Cavana from Italy, who has been a lawyer at Studio Legale Mordiglia since 2000. Cecilia focused her practice on maritime transport, advising and assisting P&I clubs, ship owners, and tour operators in matters and disputes relating to cargo loss and damages, major casualties, personal injuries, cruise operations, transport of passengers, arrest and attachment of vessels, and bank funds. She is a member of the Italian Maritime Law Association and contributes to specialist magazines and newsletters. She will give her perspective of the implementation of the MLC in her country. Please, Cecilia, you can start when you are ready.
Thank you, Roberto. Thank you, Kincaid, for inviting me. Thank you to the other speakers for their contribution. This is a very interesting topic. It's very, I mean, it's a really important progress in the life of the seafarers for sure, because it's, as Augusto was saying, is the way of, you know, putting in one instrument all the previous regulation and to modernize and also to make it something that is, let's say, recognize the rights of the seafarers in a right to a safe and let's say comfortable workplace and the relevant conditions. So I will start my presentation. Okay. If I can, all right. All right. So Italy has ratified the MLC in 2013, in September 2013. And so the convention entered into force in Italy in November 2014. Was the law that ratified the MLC, instead of spreading the provision in different various laws, it was just a law saying the government is authorized to ratify this convention in its whole. So all the provision of the convention have been ratified and are now considered as domestic law, as Italian domestic law. And the convention, this law of ratification, also provided very few changes in already existing domestic provision that were contained mainly in the Code of Navigation. So in accordance with the standard A4.5 regarding social security, the Italian government provided the specified what are the branches of social security that are implemented and are provided for by Italy, and which are sickness benefit, unemployment, and so on and on, which were already existing. Italy had already ratified many previous convention and had in place domestic law providing for the seafarers. So, I mean, has been a change in a way that has made one provision with all inside, but the attention to the security, safety, and the benefits for the seafarers was already existing. Then the other amendments that have been made to the convention were entered into force as for the instrument of the convention without the need of a proper ratification. So, as I said, in the implementation, there were few changes in the already existing provision on work, on labor, on maritime labor that was contained in the Code of Navigation. Specifically, there was the amendment of Article 119 on the minimum age that was brought from 15 to 16 years, on the repatriation of foreign seamen aboard Italian flag ships that previously was just on a terms of reciprocity between the states. Now is standard for any foreign seaman. There is a duty to be repatriated. Then there's been a few amendments on desertion and violation of an order of crew member. There has been an amendment to the to a law regarding the validity of the medical certificates and the let's say the form of drafting these medical certificates, which are now in compliance with the provision of the Maritime Labour Convention. The provision of the Maritime Labour Convention were also brought into the collective bargaining agreements that were most were renewed in 2015. And so in order to comply with the regulation of the convention, some were expressly mentioned in MLC 2006, but in general, all the provision regarding, let's say, accommodation, working hour, wages, and so on have been redrafted in a way to comply with the regulation of the convention. In particular, with regard to the 2014 amendments, which are the one that already have been indicated regarding the financial security, financial security to ensure that seafarers are able to return home in case of abandonment, and the financial security to ensure that that seafarers receive a fair compensation in case of death or long-term disability due to sickness or injury connected with their employment, which are very important and are also considered into the collective bargaining agreements, entered into force in January 2017, and the Italian government entrusted concept, which is this institute regarding private insurance, to keep the registry of the financial security that has to be provided by the insurers, mainly are provided by insurers, specifically by P&I clubs that Robert probably will talk later. And so to verify the amount of the financial security, the, let's say, strength of the provider of this security, and to issue the relevant certificates, and also the agreement for the issue of the MLC blue cards. So we have our firm assisted several P&I clubs and other insurers in relating with this institute in order to provide all this information and be recognized and receive these MLC blue cards. The compliance and enforcement of the MLC, which is dealt with at Title 5 of the Convention, that states that the compliance are to be is the responsibility of both the flag state, so the one that issued the certificate, and of the port state where the ship flying any flag is entering. As already said, and the MLC is the fourth pillar of maritime international law, so it is very important also to comply with this. With regard to flag state responsibility, and replying in advance to one of the questions I've seen, in Italy, the let's say issue of relevant certificates, which is the let's say it's priority of the Ministry of Transport, has been entrusted to some recognized organization, like also some class certificates, like RINA as a double acts also as a recognized organization. Port state control is instead made by dealt with by the special officers of the Harbor Master, which is a branch of the Italian Navy, which go and are trained to go and visit the any ship entering. There are very few of these officers that are, let's say, regionally positioned, but also travel around Italian ports to check on ships. And this, as you know, the Maritime Labor Convention provides that is applicable to all ships of the flag of a state party, but also to any ship entering a port of a state party, which means that even a ship flying a flag of whatever state that is not a party of MLC is subject to the compliance and is subject to inspection to verify the compliance of to the Maritime Labor Convention. So the port state control inspection is starts, of course, with a simple documentary inspection of all the certificate, the declaration of compliance to the MLC. And then there can be some further inspection and some, let's say, more thorough inspection in case of particular issues. We have requested the local PSC officer, what are the most frequent violations that they have detected regarding the MLC, and those are violations regarding the safety of the workplace in general, the accommodation, which is one a very important issue of the MLC, to guarantee that seafarers have decent, comfortable, and modern, let's say, accommodation, and the registry of working hours, both as registry missing or registry of working hours that are extra, that exceed the minimum or the maximum, let's say, available and reasonable for seafarers. Then, as we said, we are talking about the implementation of the MLC. Italy has been, let's say, has implemented it quite recently. So far, we haven't seen many, let's say, claims or many cases. I've tried to find some decision of the Italian tribunals, but found absolutely none. Either because or because it's I mean, Italian ship owners are very compliant, or because there are not. We, as a law firm, we have been requested sometimes to advise ship owner or yacht owners also, or manager of yacht, regarding especially the, let's say, provisions of the MLC on injury, on medical care, on responsibility, on this kind of the ship owner liability towards the crew member after injuries, how long, how much, or this kind of things. But on the other hand, the Maritime Labor Convention provides that the fact that, I mean, all the states have to control and to report on the application of the convention to their domestic law, and a special committee of ILO is also in charge of verifying the correct application and to reply and to ask the various governments for some amendments, for some clarification. And this ILO committee of experts in 2019 adopted a report that addressed to the Italian government some issues on the application, which are still to be, let's say, dealt with. Some have been already dealt with, and some have to be still to be dealt with. And so I've highlighted some of the most important. One of the most important is the one that regards the definition of seafarers and the scope of application of the convention with regard to medical certificate, with regard to employment agreements. As you know, the onboard ships, especially cruise ships, all the, let's say, general complementary services, all the services that are not work, that are not linked to the navigation, can be with in Italy, can be with a law that is dated in 1986, can be contracted to providers of these services, which can be Italian, can be foreigner, which provide the service, the hotel services, let's say, with their own organization and with their own personnel. And the personnel of this contractor, the personnel that is working on this kind of services is not part of the crew as indicated and as defined by Article 115 of the Italian Code of Navigation. And so one of the issues that has been highlighted is the fact that there is this distinction in Italian law, and some of the provision applicable to seafarers are specifically indicated as applicable to seafarers who are part of the crew, is a violation of Article 2 of the MLC, which provides that seafarer is any individual that at any in any quality and any capacity works on board a ship. So the Italian government has been requested to let's say to give clarification, and although it provided clarification saying that in case of this contract of general services, the provider is also requested to maintain the same, to be compliant with MLC, to have contracts which are in line with the contract for seafarers and which are drafted in compliance with the MLC. In any case, the ILO committee requested the Italian government to specifically include in the various law provision, any seafarers, so kind of, let's say, make equal the seafarers linked to navigation and those which services not linked to navigation. Then there's been some issue. There is still an issue regarding the minimum age for hazardous work, which is 18 years old. But in Italy, there is still some provision that say that whenever the seafarer, the younger seafarer, is training and with a supervisor, it can be for, let's say, part of his apprentice is also to be put to hazardous work, which the committee has clearly stated that is absolutely in violation of the convention. Other minor issues are those relating to the social security contribution for seafarers working on board Italian flag ships, and differences and slight let's say differences that are existing between those contributions and the contribution for seafarers who are resident in Italy and employed on board non-Italian flagged ships. And so this has been another thing that has been highlighted. And finally, with regard to the financial security, both in the event of abandonment and in the event of death and long-term disability, whilst the convention expressly requested the governments, the member states, to indicate the financial security system, the law provision that contain this financial security, indicate to the seafarers how this work. The Italian government didn't provide this this law provision, didn't specifically make it a little bit, let's say, difficult to seafarers to understand exactly what are their, I wouldn't call them options, but what are their rights whenever this case, which are very, very sad and very difficult for them, occur. So with this, I thank you very much for your attention, and I leave it to the other. Thank you.
Thank you, Cecilia, for an excellent presentation as well. You highlighted important points about the definition of seafarers. This is very important for us here in Brazil too. And the amendments that took place in the Italian legislation, which I'm sure will help us here in Brazil to understand the effects of MLC in our legal system. Very nice, Cecilia. Our last speaker of the day will bring us a quite relevant topic. It is the MLC from a club's perspective. I invite Robert Robinson, who has been working at the north of England for 11 years, specifically handling personal injury and people claims. He's part of the cross-departmental team that have been involved in most MLC claims that North of England have faced to date. Robert, it's also a pleasure to have you here, and feel free to start when you are ready.
Thank you, Roberto, and thank you to Kincaid for organising this event. The international group consider crew welfare to be of the highest priority, so we fully endorse the MLC, and I thought it might be interesting for the audience to gain the perspective of a P&I club of the MLC. Now, in very basic terms, as has been set out previously by the fellow speakers, the MLC sets out minimum standards for crew serving on board a vessel. But as such, this did not initially impact P&I clubs a great deal. However, as both Richard and Cecilia have mentioned, the 2014 amendments, which came into force on the 18th of January 2017, required that all ships subject to the MLC must carry and display on board 2 certificates confirming that financial security is in place for ship owners' liabilities for repatriation of crew, essential needs such as food, accommodation, and medical care, and up to 4 months outstanding contractual wages and entitlements in the event of abandonment. That is Regulation 2.5. And the other security is for contractual payments for death or long-term disability due to an occupational injury, illness, or hazard set out in the employment agreement or collective agreement, which is Regulation 4.2. Now, the liabilities stated under Regulation 4.2 for disability due to occupational injury, etc., those normally fall within the scope of your standard crew cover under the P&I rules. Repatriation and unpaid wages will be covered under the rules in some cases, including when due to a shipwreck. However, the liabilities stated under Regulation 2.5 relating to repatriation overdue wages fall outside the scope of P&I cover when arising from abandonment due to a ship owner's financial default. Now, a seafarer is deemed to have been abandoned where the ship owner fails to cover the cost of repatriation, maintenance support, or fails to pay contractual wages for a period of at least 2 months. Now, as the regulations set, a seafarer can claim up to 4 months contractual wages, but they cannot initiate a claim until they have missed out on 2 months. Now, in order to assist their members, the IG clubs agreed to provide the necessary financial security by way of an extension clause to the P&I rules, and this was done at no extra cost to the ship owner members. Now, it must be stated that this extension clause is an agreement to provide financial security in the required certification. It's not an agreement to cover the MLC risks. When those MLC conditions are met, clubs will pay the seafarers' claims directly. However, the member and the joint members of the entity must indemnify the club for any payments made. Assistance must be provided to the seafarer promptly and be supported by necessary justification of entitlement. However, there is scope for reasonable investigation into the claims to take place. Once the seafarer's claim is paid, the club will look to acquire the seafarer's rights by subrogation or otherwise. Now, from the club's perspective, acquiring the seafarer's rights is important. As previously mentioned, the members and joint members must indemnify the club for any payments made. However, such claims usually derive as a result of a ship owner's financial default, and as such, they would not be in a financial position to indemnify the club. If the ship were to be sold to service the debt, the P&I club would be lower down on the list of recipients of any proceeds of the sale. The crew, on the other hand, will usually be one of the first to be paid. Clubs therefore desire to take the seafarer's position at the top of this list to ensure that any amount paid to the crew by the club can subsequently be recovered. Now, fortunately, North of England has had limited exposure to MLC claims, and many of the inquiries that our MLC team have received have generally been resolved by the ship owner directly. We do concur with the previous speakers that the claims and inquiries that we've seen have predominantly been related to unpaid wages. Now, what I wanted to do is just go through a couple of case studies that the North of England has handled to give real-world context to the practicalities and challenges of dealing with such claims. The very first MLC claim that the North were involved with related to a vessel that had been under arrest in Singapore for some time. In February 2017, a chief engineer had contacted the club directly using the contact details displayed on the financial security certificate on board, and advised that he and several other crew members had completed their contracts in October 2016, but sign-off had not yet been arranged. They also reported that they had not been paid the previous 2 months' salary. It therefore appeared that the crew had been abandoned by the ship owner, and the club acknowledged directly with the chief engineer that we would investigate the situation. Now, what these investigations uncovered were that there was 20 crew on board the vessel, and the contracts of 14 of those crew had expired. One crew member even was suffering from a medical condition which required treatment and repatriation. Now, what our further investigations led us to understand was that the vessel was actually soon to be sold, and the intention of the ship owner was to pay the crew using the sale. They had asked the sheriff in Singapore if that was possible, but this was rejected. What the sheriff did agree to do was pay the crew wages for October. Unfortunately, there had been a breakdown in communication between the owner and the sheriff, with each being confused who was going to be paying, which resulted in the wages not being paid November through to the February when the chief engineer got in touch with the club. Now, in this situation, the court actually resolved by instructing their own agents, who they agreed would be able to recover the expenses from the vessel's sale. And these agents settled the outstanding crew wages and arranged repatriation for all 20 crew. Now, obviously, they couldn't leave the vessel unmanned, and so the court's agents also placed their own skeleton crew on board. From North's perspective, this was a good result, as all the crew were paid and repatriated, and most importantly, the seafarer received treatment, without the need for us as a club to become too involved financially or otherwise. It goes without saying that 4 months' wages for 14 crew members would have resulted in a significant claim on the club, with no guarantee that we could recover the amount paid. We were less fortunate in 2019. This second case study demonstrates the financial risk that the clubs have by providing financial security for their members. This incident involved a fleet of 6 vessels, 107 seafarers, and a total amount paid by the club of almost $1.2 million US. North received several messages from the masters of their respective vessels advising of unpaid wages, and in some cases, lack of provisions on board. North also received messages of concern from respective maritime unions, of the 107 crew on board, there was a mix of nationalities, majority of which were Indian, but there was also Ukrainian and a few other nationalities. Despite assurances from the ship owner that they were working with their bank to resolve the situation, North was coming under increased pressure from the crew and the authorities to step in and meet the obligations set out by the financial security that the club had provided. It then transpired that the owner was able to remit funds in an attempt to resolve the outstanding wages, which seemed positive. However, they were doing so via their local agents in India, with whom they also had debts. As such, once the agents received the money, they took what they were owed, and the remaining was not enough to cover the outstanding wages to the crew or supply the vessels with adequate provisions. At this point, the club had to step in, and with the help of our local correspondents in India, began the process of resupplying the vessels with provisions, whilst we tried to obtain a crew list for each vessel and the relevant contractual documents to ascertain the monthly wage of each seafarer. As crew was signed off the vessel, we obtained deeds of subrogation in addition to release documents in return for the amounts owed to each seafarer, which North paid via our local correspondent. As mentioned earlier, owners indemnify the club for any amounts paid under the financial security obligation, and in this case, we were able to obtain a full recovery of the total amount paid. Needless to say, all MLC claims have challenges to overcome, and each situation needs to be handled on its own merits. North would, however, not be in a position to assist crew and owners in these situations if it was not for the valued assistance and expertise of our local correspondents. What is more, it takes a collective effort of everyone involved, from the club, agents, correspondents, and the local authorities, to resolve these situations and ensure that the crew's welfare is always the primary objective. I think I've gone through that a lot quicker than when I practiced, but thank you very much for listening to me. I look forward to answering any questions, and hand back to Roberto.
Thank you, Robert, for also an excellent presentation. On the practical aspect related to P&I clubs, your explanation sure help everyone to reflect about the non-compliance of MLC rules and its consequences. So thank you again. Let's start to the debate section. I will pass the word now to Juliana, that will moderate a brief Q&A section. Juliana, please.
Hi, everyone. Good afternoon. So I know Roberto has already introduced me, but for those of you that were here, I'm Juliana. I'm a labor lawyer here at Kincaid, and I'll be handling the Q&A. Personally, I'd like to thank all the speakers for the great presentations. It means a lot to our firms to hear the perspectives from a labor public prosecutor with so much experience in the field, as well as from lawyers that are already dealing with that MLC since 2013, and from the P&I Club. It will definitely help us in the challenges that we will be facing applying the MLC in our very protective labor law system. So we also thank everyone for attending the event and for sending us questions. We will be planning another events regarding these matters for sure. So now I will start the Q&A. First, I have a question for Richard. Richard, considering the potential personal injury and wages claims related to the MLC were briefly commented during the initial speeches, can you elaborate a little bit on some of the main types of claims in your experience and talk a little bit more about them?
Yes, thank you, Juliana, for your question. As also touched upon by Robert, the types of claims that we see and deal with MLC related, inter alia, they are claims concerning the financial security. So as of 2008, of course, we have seen a downfall in business, and we have seen a lot of ship owners in financial difficulty, and among those some Dutch flagged vessels with Dutch owners, also ships in other foreign jurisdictions, where crew remained unpaid. And local ITF stepped in and summoned the Dutch ship owners to repatriate and pay the wages as yet, which was impossible. And then we were contacted by the P&I Club to deal with that case. And in that case, wages had not been paid. The ship was in the meantime also under arrest by local authorities. There was no more power on board the vessel, therefore also no power to keep the fridges going, and the cold storage facilities broke down. There was no more food on board, and we had to use local agents also to get food on board, to arrange for repatriation, buy tickets to get them out of there. They were about 100 kilometers away from the United States, but they could not fly through the United States because they did not have the necessary documents, visa. So they had to travel halfway around the world via London. Everything had to be arranged. And ultimately, we succeeded. But that ship owners went bankrupt and there was no recovery for the club. So those are the types of cases we see. As regards to personal injury cases, we see the cases where they will lodge a claim under Dutch law, but it is also lodged using the MLC 2006, specifically the provisions regarding the accommodations in case of crew that have slipped or in another manner suffered injuries on board a vessel. So yes, it's in a certain way also fairly recent in the Netherlands that MLC cases are being conducted through the courts, but they're not all that many, maybe 10 to 20 at most.
Thank you. Thank you very much, Richard. We have now 2 questions for Robert from the P&I Club. So Robert, regarding the unpaid crew wages, how can the MLC safeguard seafarers and prevent the risks of abandonment of the vessel? Also, the ship owners and clubs should be prepared to respond to this type of situation. How can they be prepared? Can you help us with these questions, please?
Thanks, Juliana. I think with abandonment, it's the ship owner is going to be in financial difficulty. So it's difficult for the MLC to prevent this, but the safeguard is the financial security that has to be in place. Now, the IG have agreed to put this up, but it doesn't have to be an IG P&I club that puts up the security. As a P&I club, as part of the IG, we are prepared to pay for the repatriation and the sick wages, and that's how we safeguard the seafarers from these situations that they unfortunately find themselves in. Now, we do that via our local correspondence, as I alluded to in my second case study, and as Richard has mentioned, he's been involved directly with that, with helping repatriating crew from anywhere in the world. Does that answer your question, Juliana?
Yeah, it's great. So I have some questions for Augusto too. So Augusto, about Robert's exposition, we would like to ask if you can tell us a little bit about the event that occurred here in Brazil involving the abandonment of the vessel Isracane. I don't know if I'm pronouncing right. I hope so. But if you can tell a little bit about it.
Isracane is okay. I call the saga of the Isracane ship. It's very interesting because she was abandoned twice in 1 year in Brazil. Isracane, I think, is the spell is like that. I don't know surely. Is a Panamanian flagged ship, began to present problems in Brazil last year, 2020, more specifically at the port of São Sebastião in the state of São Paulo. After notification from the seat, is a labor inspector, a labor prosecutor office in São José dos Campos, filed a public civil class action in the São Sebastião Labor Court, requesting to arrest the ship in order to guarantee the payment of wages in future labor execution, as well as guarantees regarding to health and safety on the vessel's workers. The case is very similar that Richard has told to us. No food, no water, problem with the payment of the crew. Interesting that the judiciary judge itself incompetent to consider the matter since the vessel was at sea, it not dock on Brazil land, and those involved are foreigners, not Brazilian sea affairs, and there is no employment relationship contract ought to be carried out in Brazil. So before appealing the court's decision, the MPT, the labor prosecutor officer, and other agencies like the Navy, met a hearing to seek an eventual extrajudicial solution to the matter with the ship's operator. 2 meetings were held. I was there with the participation of some agents, so federal agents, and the solution that is investing company appeared with its legal representatives, who agreed to enter into agreement to express the need to transport its cargo to another destination, and paid all the wages and all the wages to the crew. I want to highlight that the General Consulate of Ukraine contracts a law firm, and the 2 very competent lawyers, Dr. Maria Botijo and Dr. Antonio Lavand, who represent the consulate, the interests of the consulate of Ukraine, contributes to the solution without to appeal from the sentence of the judge. However, the ship, the investors that become the operators of the ship pay all the rates and repatriate the CFS who so wish. However, the ship was again abandoned in Santos, also in São Paulo this year, and another inspection was by the label fiscal auditors in Santos, and another action, another class action was in order. So in this case, the judge respond to the MPT's requests, determining that the crew were repatriated due to the situation of abandonment of the ship, and that the companies involved in the case disembarked the CFS, which has expired contracts. And in this case, the P&I Club was called for the representation of the crew based on the insurance required by the MLC, like Robert has told with the 24 amendment for the insurance, it was required. It's a very interesting case. It's not over yet, but I think is a great experience for the Brazilian authorities that will face a lot of these cases in the past, and I think in the future also will be relative common, unfortunately.
Thank you, Augusto. This is a really interesting case. We have a last question here from Tatiani from LS Consultory, and she wants to know, and this question is also for Augusto, because I think he'll be better at responding it. In Brazil, will the inspections on the MLC be made by the classification society, or which organs will make the inspections?
Okay. Tatiana, thank you for the question. Yes, for the issuance of statutory certificates that demanded by the MLC, the Maritime Authority, the Brazilian Navy delegates this attribution of inspections to classification societies, yes. The Navy has adopted this system, it's important to tell you, in line with another International Maritime Organization conventions, and will continue to use classification societies for statutory inspections. But it's important to tell you that the port state control, however, is under the responsibility of the Department of Portos and Coasts, DPC, Departamento Diretoria de Portos e Costas in Portuguese, responsible for naval inspections. So yes, the answer is yes, the classification society will be used to special to the statutory certificate and the renovation certificate also.
Thank you very much, Augusto. I'll pass to Roberto so he can share his closing arguments. And thank you all for the attendance and the great presentations. It was very helpful and interesting.
Yeah, we would like to dedicate a big thanks to our qualified team of speakers for sharing such interesting views on the MLC, which is certainly very helpful for a safe and correct application of the convention in Brazil. Thanks to our moderator, Juliana, and for all participants that spend time with us today. We will keep you all posted on future events organized by our firm. See you next time, and bye-bye.
Thank you. Bye-bye.
Thank you very much.
Thank you. Bye-bye. Thanks, everyone.
Bye-bye. Thank you.
Bye-bye. Have a nice day, afternoon,
Day.
whatever.
Yes.
Bye.
Bye-bye. Thank you very much.